Okay, so thank you for joining us, everyone. We welcome to this session today. Thank you for coming to this session about post-Brexit rights for LGBTQ plus people and people living with HIV, hosted by the charity Settled and supported by the EU delegation. Now, the purpose of today's event is to inform EU citizens who live and work in the UK about the EU settlement scheme and the June 21st deadline for applications. If you're an EU citizen, there are now just 2 weeks left for you to apply to the scheme to secure your rights to live, work, and access healthcare and benefits here in the UK. My name is Nathaniel Hall. I'm an actor, writer, and LGBTQ plus and HIV activist, and I'm really passionate about how art and creativity can be used to empower people to tell their own stories and help our communities thrive. I'm a gay man myself, and I've lived with HIV since I was 16. Some people might know me from my solo show, which smashes through the stigma of being gay and HIV positive, but some of you also might have seen me in the Channel 4 drama It's a Sin. You might recognise me as Donald Bassett. I'm really honoured to have been asked to present this session today. So as well as being a proud LGBTQ plus and HIV activist, I'm proud to be British and I'm a proud European. And despite the events of the past few years, I don't believe these two things have to be or are in fact mutually exclusive. Now, through my work with LGBTQ plus and HIV charities, I know that for some, navigating citizenship, immigration and asylum when you live at the intersection of being LGBTQ plus or HIV positive or both can be really stressful. If you're HIV positive or lesbian, gay, bisexual or transgender, you might be worried about being sent back to a country without the healthcare you need or one where simply being yourself puts you in danger. But burying your head in the sand won't make the June 21st deadline go away. So whether you're here to find out how to apply for yourself, for someone else, or as a representative of an organisation that is supporting LGBTQ plus people or people living with HIV, it's imperative to take that deadline seriously. Hopefully today's session will help alleviate any anxieties you or the people you're supporting might have. For those who don't know who Settled are, a bit of background. Settled is the largest volunteer-led charity with 120 volunteers here in the UK. They help EU citizens secure their future in the UK under the EU settlement scheme. Now, a little bit of housekeeping before we kick off fully. Today's session is a webinar being hosted on Zoom and also on the Settled and the EU delegation's Facebook pages. The session will be available to watch on both Settled and the EU delegation's Facebook pages after this event and Settled's YouTube page afterwards. So please do share far and wide through your networks to people who this may be important for. We have two speakers who are going to present and then we're going to have the Q&A. So first up, we have Pavel Kolodji. Now, Pavel is North Wales and Midlands Service Coordinator for Settled and is also responsible for services in Polish and Romanian. And he's going to give a short presentation about who Settled are, how they can help people applying to the EU SS. Now, Pavel has had some connection issues, is in a cafe somewhere. So if you hear someone ordering a cheese toastie in the background, that's why. Hopefully his line won't be too bad. And then we have Chris Desira. Chris is an immigration lawyer and director of Seraphus, an organisation that specialises in immigration, asylum and free movement law, and they aim to simplify the law, challenge the concept of hard borders, humanise migration and encourage integration. And Chris is also a trustee for Settled. And Chris is going to give a short presentation that will focus on busting some myths and misconceptions about the EUSS, why it is imperative everyone applies, and the potential consequences of not applying. And we also have Andras from the EU delegation supporting the session, so welcome to Andras as well. After we've done the presentations, we'll have a Q&A session. So as this is a webinar, you can put your questions in the chat box and our moderators will pass them to me and we'll try and get through as many as possible. If you are on Facebook, feel free to drop your question there. And again, someone will factor those questions through to me. We only have an hour for the session, so please don't wait until the end to ask your question and miss your chance. And please feel free to ask anything, but remember, this is a public forum, so refrain from sharing too much personal detail as your question may not be asked out loud. Questions that don't get answered can be sent to advice@settled.org.uk, and if you want to seek further support, advice or guidance on an application, you should contact that email as well. So without further ado, I'm going to invite Pavel to do his presentation.
Thank you, Nathaniel. Hi, everyone. I really apologize for the fact that I am unable to have my camera on. I will now share the presentation, and hopefully the connection would be good enough for my presentation to go on. So, Nathaniel, can you confirm that you can
Yes.
see it? Yes.
Yes, we can see
Great.
that. That's great.
Great. So thank you for the introduction. I am a service coordinator for Settled, and would give a short overview of who we are and what EUSS is. So Settled is a charity which is volunteering based. So we do not have a lot of members of staff. We have over 100 volunteers who are OISC accredited immigration advisors, and we provide advice support to EU citizens in the UK with regards to the EUSS applications, as well as other issues related with the settlement scheme. And at the moment, we provide our services via emails, telephone lines in different EU languages, as well as Facebook forums also run by our volunteers in different EU languages. So this is very important as we are getting closer and closer to the deadline. The deadline for the EU settlement scheme applications is 30th of June 2021. And because of this, there is a lot of media coverage with regards to this issue, and our workload has increased over last month, and we are receiving on a daily basis huge amount of emails, phone calls, and queries on our Facebook forum. So at the moment, we are prioritizing people who have not applied yet, or people who would like to bring their parents to the UK. However, we also would provide support to all the questions and queries we receive, but this is how we at the moment prioritize our work. So to give a little bit background for what the EUSS EU settlement scheme is. This is the scheme that has been introduced after as a consequence of the withdrawal agreement of the Brexit, and EU citizens who want to stay and keep their rights in the UK, they all must apply. On the 30th of December 2020, the freedom of movement between the EU and the UK ended, and a so-called grace period started that allows an extended period of time to apply to the EU settlement scheme. And this grace period is going to end on the 30th of June. That's why it's so important to make your application before this deadline. It's really important to keep the right in the UK to apply before the deadline, as the late applications, they will be considered, but you will have to meet some conditions, and you would have to have a good reason for the delay, and also you would have to apply within a reasonable period of time. And unfortunately, those who fail to apply, but by the deadline, they might lose their rights to reside lawfully in the UK. So to make the application, you will have to prove that you arrived in the UK before the 31st of December. You would need your valid passport or ID document. It's very useful to have a national insurance number. It's not a requirement, but it can help with the application to prove your residence in the UK. And you will also need an email address and a mobile number to be able to access your application online. It's a digital scheme. So the idea is that all the application process is done online, and this is also the way you submit the document to prove your residence, and you contact with the Home Office during the procedure. And it's very difficult at the moment to contact a resolution center as they are experiencing a lot of phone calls. But this is the number on the slide that can be contacted for the Home Office EU Settlement Resolution Center. You can see here examples of the documents that can be useful to prove your residence in the UK, and you can use this document for the purpose of your application. So they include council tax and utility bills, rental and tenancy agreements, bank statements, payslips, other employment documents, letters from school or universities, letters from GP, and also other documents. This is not an exhaustive list. So just to give you an idea of how the scheme works, as there are two different types of status that you can apply. This is a short scenario about Maria, who arrived in the UK in April 2019, and she applied for pre-settled status in April 2020, and she received an email and a letter in May 2020 saying that she has a pre-settled status. Then Maria can apply for settled status from April 2024, which is like 5 years after she arrived in the UK. And she has until May 2025 to apply for the settled status, which means it's 5 years after the date she received the pre-settled status. And it's very important that that you make this application, as this pre-settled status would not change into settled status automatically. As it was mentioned before, Settled runs services via email, telephone, and Facebook forums, and all the information about how to contact us with and in what languages you can find on our website, which is on the slide here. Thank you so much.
Thanks very much, Pavel, for that. Yeah, and I should have said at the start that the amazing volunteers at Settled are made up of people of all different nationalities, and there are a whole range of languages. So hopefully there's someone who can help support you if English is the second language to you. So we're going to move on now to Chris. So Chris, if you're ready, I'd like to kick off with your presentation.
Hello, thank you for the wonderful introduction. Thank you for inviting me to participate today. My name is Christopher Desira. I am a solicitor at the law firm called Seraphus. We provide a range of immigration advice to a range of organisations, including charities and the EU delegation. My presentation is going to be about busting some myths about the EU settlement scheme. So if that goes successful, then hopefully you won't have too many questions after this presentation. So let me share my screen and then we can begin. So hopefully everyone can see these slides. Give me a holler if you can't, and I'll try and fix this.
Yeah, we can see the slides, Chris.
Lovely. So let's get on to some myth busting. So the first myth is I have received settled status. Does that mean my children are automatically protected? Now, just because a parent applies to the settlement scheme, that doesn't mean children are automatically protected. Children do not automatically receive a status at the same time as a parent receives a status. Every individual person, whatever their age, must make an application to the scheme in order to be granted a status under the scheme. Now, there will be some situations where children may receive some form of protection because the parent has, but it's only in very specific circumstances, and some of it hasn't even become law yet. So, for example, this government is intending to introduce a law that will mean that once a parent becomes settled with settled status, the child will be born British, and that's children who were born before the parent receives settled status. And once the parent receives settled status, that child automatically becomes British once the parent receives settled status. So there will be some circumstances where children can become protected by automatic acquisition. But there are some situations where that will not occur. And I'm going to talk a bit more about children in another myth soon enough. Next myth. I have pre-settled status. Will I receive settled status automatically after living here for 5 years? Now, no, you won't automatically receive settled status. The system currently, as it stands, is that if you have pre-settled status and then you have lived in the UK continuously for a 5-year period, you will need to make another application to the EU settlement scheme in order to receive your settled status. This means repeating the application process again by downloading the app and then completing the online form and proving you've lived in the UK continuously for 5 years. Submit your application and then you will receive settled status once the Home Office have processed that application. So it doesn't automatically translate to settled status. I say currently because this is the UK government's interpretation. That interpretation is not agreed by other states, including possibly the EU. So there might be some changes in the future. However, as things stand, you don't automatically receive pre-settled status. You will need to make sure you apply to the scheme before your pre-settled status expires. Next myth. Do I have to stay in the UK while I wait for an outcome to my EU settlement scheme application? No, you don't. Once you've submitted your EU settlement scheme application, you can travel. You are free to travel. However, if you're a person that's eligible for or going to be granted pre-settled status, you do need to be aware of the additional rules for pre-settled status holders. As a pre-settled status holder or a person going to be granted pre-settled status, you must maintain your continuous residence ties in the UK in order to be eligible for settled status later. If you're a person who's applying for settled status, then you can be outside of the UK for up to 5 years without losing your eligibility to receive settled status. So it's just those who are going to receive or who are applying for pre-settled status need to make sure that they're not absent from the UK for long periods of time, but you can travel. I will talk about continuous residence in another myth because there are more myths attached to continuous residence. Next myth. I have been living in the UK for a very long time. Does that mean I am protected? No, the length of residence in the UK, however long it is, doesn't mean you're automatically protected. I've spoken to some people who have lived in the UK for 40 years, 50 years and more, and they believe that because of that long residence, they're protected in the UK. A length of residence is no protection. The only protection you might have is if you've received an alternative immigration status at some point in the past. or you are British. If you haven't received an alternative immigration status in the past, or you are not also British, you need to apply to the EU settlement scheme. No amount of residence in the UK will automatically protect you. Next myth. My passport has expired. Does that mean I can't apply until I receive a new one? No, that doesn't mean you have to wait until you get a new passport or national ID card before you apply to the EU settlement scheme. You can apply to the EU settlement scheme using expired identity documents. However, you won't be able to use the online application form if your identity document has expired. It used to be that you would have had to contact the Home Office using the call centre called the Settlement Resolution Centre to tell them that your ID document has expired and to ask them to send to you a paper application form so that once you receive it by post, you fill it in and send it back by post. However, because we're so close to the deadline and there's not enough time to post and receive and then post again these applications, the Home Office have kindly provided these online application form, these paper application forms online on their Home Office website as of yesterday. So if your passport or national ID card has expired, then you can visit the .gov.uk website. You can download these paper application forms, and then you can either complete them digitally and email them to the email address contained on the form, or you can print them off, fill them in, and post them to the Home Office. You no longer have to call the Settlement Resolution Centre to ask for these application forms. Next myth. Does my current employer have to see my EU settlement scheme status? Now, the answer is no in most cases. If your employer has already checked your right to work, this is by checking your ID document, that's either your passport or national ID card, and they've done this during your current period of employment, and they've done this before the end of June, then your employer does not need to recheck your immigration status. There are no obligations on employers to do so. However, the employer can recheck your immigration status, but they can only do it if it's in a non-discriminatory way. This means they can't just focus on you because you're a European citizen. If they're checking your status, it needs to be as part of a policy that's checking everyone's status. If your employer does need to check your status and they're doing it in a non-discriminatory way, they can do this either by a manual check. This is by asking to see your ID documents and checking your digital status, which you can share to them securely. Or they can use an online right to work check, which is hosted on the Home Office website, and they can digitally check directly with the Home Office that they can continue employing you. However, you have the choice which methods that they can use. You can choose the manual method, or you can allow them to check with the Home Office directly. If you haven't received your pre-settled or settled status, they will also be able to check your right to work by viewing your certificate of application, which you would have received when you applied to the EU settlement scheme, but before you receive your pre-settled or settled status. Or if you've applied to the EU settlement scheme and you've subsequently become British, they can check by looking at your British passport, or if you don't have a British passport, they can view your naturalisation certificate. So let's see the next myth. The next myth is, I do not have a comprehensive sickness health insurance. Does that mean I will be refused settled status? Now, that doesn't mean you're going to be refused settled status. The EU settlement scheme, either pre-settled or settled status, is concerned about your presence in the UK, not what you are doing while you're inside the UK. So it doesn't matter if you don't have sickness health insurance coverage. It doesn't matter if you're employed, self-employed, you're unemployed, you're on benefits, you're a pensioner, or you're supported by family members. What you're doing in the UK, how you're supporting yourself in the UK, and your activities in the UK is irrelevant to the application. All you need to prove is your presence. So that's evidence that you're continuously residing in the UK for 5 years if you're applying for settled status, or you were present in the UK before the end of last year and you remain in the UK if you're applying for pre-settled status. Next myth. I have not received my settled status yet. Does that mean I'm not protected after the 30th of June 2021 deadline? Now, that doesn't mean you're not protected. If you've applied before the 30th of June deadline, then it doesn't matter that you've not yet received your pre-settled or settled status. You can continue waiting in the UK while the application is being processed. If anyone, like I've suggested in the previous myth, needs to check your status, such as an employer, you can always show them your certificate of application. This will be a certificate that the Home Office sends to you when you've made your application, which will confirm that you've made an application and will confirm your rights and entitlements while you are waiting the outcome to that application. So this certificate can be shown to third parties such as employers or landlords or banks and so on, to show that you made a valid application and you're still awaiting an outcome to the status. Now, the next myth, this is quite a big one because it touches on various other myths as well. So the answer to this question is going to be a bit long, so bear with me. Now, this myth is, I have been outside of the UK for over 6 months. Does that mean I am no longer able to get settled status? Now, just because you've been outside of the UK for more than 6 months doesn't mean you're not able to apply to the EU settlement scheme. You might still be eligible for settled status, but you will need to explain your reasons for your absence. Now, there are many types of absences and there are many types of reasons, and the Home Office have recently updated the guidance on absences for those who are applying for settled status. Now, the guidance is long, but bear with me, I'm going to cover some of the important parts of it now because some of it will be relevant to you. So you can be outside of the UK for over 6 months, but not less than 12 months if it's for an important reason. Now, important reasons can include pregnancy, childbirth, serious illness, study, vocational training, or an overseas posting. Now, the Home Office have accepted that absences of up to 12 months for an important reason can include coronavirus-related important reasons. So if your absence is more than 6 months, but less than 12 months, it can be still okay, so long as you can prove you were either ill with the coronavirus, you were in quarantine, self-isolating or shielding, or you were caring for family members affected by the coronavirus, or you were prevented from returning earlier to the UK due to travel restrictions caused by the coronavirus, or you were advised by your university that due to the coronavirus, your course was moved to remote working and you were advised to stay where you are and study remotely, or you were advised by your employer not to return to the UK and continue working remotely from your home country. So these are the types of important reasons that the Home Office will accept for an absence of more than 6 months, but less than 12 months. However, the Home Office will, in certain circumstances, accept people's absences of over 12 months and also accepts that this does not break the person's continuous residence in the UK. For absences over 12 months, it must be coronavirus related. You must have been prevented from or advised against returning in the UK earlier, and that you've exceeded 12 months for a period afterwards, and you've returned to the UK as quickly as possible. And you must have evidence that it was coronavirus related. And some coronavirus related reasons include being ill with the coronavirus, being in quarantine, self-isolation, or shielding in accordance with local health restrictions, or you were caring for a family member affected by the coronavirus, or you were prevented from returning earlier due to travel disruptions caused by the coronavirus, or you were advised by your university or your employer not to return to the UK and to continue studying or working remotely from your home country because of the coronavirus. you will need evidence, and the Home Office will expect to see evidence of this absence exceeding 12 months. Usually you're only allowed one absence of up to 12 months or more within your 5-year period, but the Home Office will accept a second absence of up to 12 months or more, so long as the first absence was for other important reasons not related to coronavirus, and the second long absence was related to the coronavirus. Now, this is a very long answer, and it's a complex situation. Please read the guidance that's hosted on the Home Office website about coronavirus-related absences under the EU settlement scheme. And if you need to find it, you can just Google something to that effect. So the next myth. I have been outside of the UK for over 12 months, and it wasn't really related to an important reason or the coronavirus. But I have returned to the UK in 2021. Can I reapply for pre-settled status? In this scenario, you can't reapply for pre-settled status. Some people can reapply for a second grant of pre-settled status, but this would only work if your return to the UK was before the end of last year. This is because you can only restart your residence connections in the UK if your return was at some point before the end of last year. That's the cutoff date for reconnecting your residence and being eligible for a status under the EU settlement scheme. If your return was in 2021 and it doesn't look like your long absence was for an important reason, then it doesn't stop you from trying to apply for settled status, but the chances are that you may be refused settled status because you have no important reasons to justify that long absence. If you think you're in this situation, it would be probably good to seek advice from a lawyer or from Settled or from any other charities before you apply for settled status, because you're going to need to present your application as strongly as possible to try and see if there's some way of overcoming the break in your continuous residence. Next myth. I have settled status and I'm outside of the UK. Will I be stopped at the border when re-entering? No, you won't be stopped at the border. And there has been a lot of news about this, about people who have been stopped at the borders and they have pre-settled or settled status, or they're eligible to apply for it. Now, it is recommended that you do travel on an identity document that's linked to your digital status, because this will make entering the UK more efficient, and hopefully the digital checks will be able to grant you entry automatically. Now, for those people who have suffered some obstacles when re-entering, it's because UK border staff can select to ask questions of people re-entering the UK. And some people can be refused entry if it's for security reasons, or because a person no longer meets the requirements of the EU settlement scheme, or a person does not hold valid leave to enter. For example, a family member joining you in the UK hasn't first applied for a family permit. These reasons can be used to refuse a person's entry. If this occurs, you'll be expected to leave the UK and return home. And once you've returned home, seek advice from a UK-based charity or lawyer so we can avoid these problems reoccurring when you next try to come to the UK. It's always been the case that border agents can ask questions even if you do have pre-settled settled status. So if you are asked questions by border force staff, please answer them politely and with respect to avoid any problems with those particular border agents, and explain to them that you have pre-settled or settled status, or you're awaiting an outcome to your pre-settled or settled status application. If you're a family member applying to join your EU sponsor in the UK, explain that you hold an EU settlement scheme family permit, and the border staff will check that you hold the right permit and grant you entry in the UK. Now, the Home Office will continue to change the borders to ensure that information is checked digitally and automatically on arrival. So to reduce any problems, make sure your pre-settled or settled status is up to date and your current ID document is linked to that status. If you get a new ID document, update your EU settlement scheme status with that new document. And if either your old document is still valid and your new document is linked to your EU settlement scheme, you can choose to travel on either of those. And because both of them are linked to your settled status or pre-settled status, you should automatically be gained entry. It's important to note that only EU citizens who are eligible for pre-settled or settled status or otherwise protected by the withdrawal agreements can continue to use national ID cards for travel. Any other EU citizens will only be able to use national ID cards for travel up to the 1st of October 2021. Afterwards, they can only use a passport to travel into the UK. Now, next myth, we're back to children again. My child was born after I received pre-settled status. Does that mean they automatically receive pre-settled status themselves? No, it doesn't. If your parents receive pre-settled status, you will also need to make an individual application for pre-settled status yourself. It's really important for children to understand what children's immigration or nationality status is. The starting point for children should be to assume that your child needs to register on the EU settlement scheme unless you're absolutely sure they do not need to do so. Your child will not need to apply to the EU settlement scheme if your child is an Irish citizen, but they can choose to apply. Your child doesn't need to apply to the EU settlement scheme if they have an alternative indefinite leave to remain status under another part of the immigration system, but they can choose to do so. Your child doesn't and cannot apply to the EU settlement scheme if your child also holds British citizenship. So by the end of this month, make sure your child is in one of the following situations. You confirm that your child is born British. We recommend getting a British passport to validate that. Make sure your child has been registered as British. However, there's not much time to do that option. Confirm that your child is Irish or otherwise holds indefinite leave to remain. If you can't get a British passport in time, you can't register your child in time, you're not sure if your child is Irish, or you're not sure if your child holds an alternative indefinite leave to remain, then make sure you apply to the EU settlement scheme for pre-settled or settled status before the deadline, and then you can solve your child's citizenship afterwards. Next myth, if I don't apply, I will still be able to continue accessing my HIV or any other medical treatment. Now, if you don't apply, you won't be able to continue accessing any type of medical treatment after the 30th of June 2021 deadline. Your rights to medical treatment will be interrupted from the 1st of July and until such time you receive pre-settled or settled status later. So to avoid any interruptions with medical treatment or any other rights and entitlements inside the UK, please make sure you apply before the end of this month to ensure that your rights and entitlements remain uninterrupted. If you miss the deadline, you might be able to apply late and restart those rights, but you'll only be able to restart those rights according to the UK government once you've received pre-settled and settled status later, which means there could be weeks or many months before you're able to restart your rights and entitlements in the UK. Next myth. Because we're not married or in a civil partnership, my partner, who's living with me in the UK, will not be able to get settled status. Now, that's not correct. You don't need to be married or in a civil partnership for your partner to also be eligible for pre-settled or settled status. However, you do need to have been living lawfully together. What this means is that if you're living together and your partner doesn't have any other alternative immigration status, then you would need to have obtained a residence document under EU law before the end of last year. If you're living with your partner and your partner has an alternative immigration status, for example, they're here on a student visa, then this would also mean that you are living lawfully together. So your partner can, if they're in the UK and was living lawfully in the UK before the end of last year, also apply for pre-settled or settled status. They don't need to be married or enter in a civil partnership to do so. Next myth. Is it better if I don't apply? Because if my application is rejected, I will immediately be sent back to a country where I will face discrimination or worse. Now, it's not better and it's not a solution to avoid making an application to the EU settlement scheme just because you're worried about the outcome to it. If you avoid the EU settlement scheme, your problems will become much worse. Your rights and entitlements will stop in the UK. And if you ultimately don't make an application as soon as you can after the deadline, or you've been asked to do so by the Home Office and you've refused to do so, then the Home Office do have the power to forcibly remove you back to a country where you will face discrimination or worse. So it's much better to engage with the system, even though you might be worried about the outcome of your application. Now, it might be that your worries about this application are not so serious, that in fact you are eligible for a status and your application will be quite straightforward. But if you do have anxieties about your application and you are worried it's going to be refused, the best solution is to seek advice from Settled or from any other lawyer and talk to them about your application, talk to them about your worries about it and why you think it will be refused. The chances are it won't be refused, and you can have the reassurance from the person giving you advice that you should apply and your application is likely to be successful. It's much better to apply than be refused. Even if you are refused, and the chances of being refused are immensely low, even if you are refused, you won't be asked to leave the UK immediately. You can challenge the decision by appealing it, and you will be able to continue living in the UK and accessing your rights and entitlements in the UK while you go through that appeals process. And it will only be once you've exhausted any type of remedy will then the Home Office expect you to leave the UK. So even if you're refused, you've still got a long journey ahead of you and you can continue living here. The main point is that you must apply before the deadline to protect yourself in the long term. Next myth. I can bring my parents into the UK anytime, no questions asked. Is that correct? No, that's not correct. Your parents can join you in the UK, but they need to be dependent on you to have a right to join you in the UK. They can't just join you just because they're your parents. They need to have some level of dependency attached to you to be able to come to you and then continue accessing that dependency from you inside the UK. Dependency is not strictly defined. It means that the joining family member, your parents, will require assistance from you, the EU sponsor, or your spouse or civil partner. The assistance needs to meet your parents' essential living needs. In many cases, this can be financial support, but it's not limited to financial support. It can be any other types of help that's considered material in order to meet their essential living needs in whole or in part. So if they are dependent on you and you have evidence of their dependency, then your parents can apply by providing evidence of their dependency, and then they can join you in the UK. Next myth. I'm the sole carer of my child. My child's other parents doesn't agree that my child should apply to the EU settlement scheme, and so my child can't apply to the scheme. This is not true. Your child can apply to the scheme, and a child can apply to the scheme regardless of the consent of the parent or any parent indeed. So it doesn't matter the views of the parents. The child can apply to the scheme, and the child should apply to the scheme before the 30th of June 2021 deadline. Next myth. My family members living outside of the UK are European. They can enter the UK visa-free and then apply for pre-settled or settled status after they've arrived in the UK. Now, this is not correct. Although European family members can enter the UK visa-free as visitors, they can't, when they're inside the UK as a visitor, apply to the EU settlement scheme. If they do this, they will be eventually refused pre-settled or settled status, and also the majority of their time in the UK will be considered unlawful and in breach of immigration laws. So you don't want to use the visitor process to enter the UK and then enter the EU settlement scheme process. What your family members should do, they should apply for an EU settlement scheme family permit before they travel to the UK. Once they've received their EU settlement scheme family permits, they can then travel to the UK on that family permit, and then they must, once they've arrived in the UK and within 3 months of that arrival, apply for pre-settled or settled status. Next myth. I have a speeding fine and a parking ticket, like we all do. I should avoid applying because I will be refused for those reasons. No, you shouldn't avoid applying. You won't be refused by having a speeding fine, having a parking fine, or having any other types of fixed penalty notices, or in fact any imprisonment which is less than 12 months. The Home Office are only looking for serious offending, which it means an imprisoned sentence of 12 months or more if the offence occurred before the end of last year. So it's not advisable to avoid applying to the EU settlement scheme because you're worried you might be refused because of any type of offending. And in fact, it's not advisable to avoid the EU settlement scheme, even if you possess a serious offence. You should engage with the process because, again, avoiding the EU settlement scheme will cause much more problems for you in the long run, and will become a much harder process to get pre-settled or settled status later on. If you have serious offending, speak to a lawyer first, speak to someone that's settled first, consider how that offending will affect the outcome of your application, and then you can consider how you frame your application before you make it. But you don't have much time to do this because the deadline is fast approaching. Seek advice now. Next myth. If I miss the 30th of June deadline, I will never be able to get pre-settled or settled status. This is not correct. Even if you miss the deadline, you can still apply for pre-settled or settled status. You can apply to the EU settlement scheme late and after the deadline, but you must have good reasons for doing so, and you must have applied as soon as you realise you should have applied. However, please be aware, don't use this as a fallback option for you to avoid the process now. Even if you can apply late, your rights and entitlements will be stopped from the 1st of July and until such time you receive status. So if you want to continue exercising all of your rights and entitlements in the UK, please apply before the 30th of June 2021 deadline. Next myth, and the last myth. I can get legal advice from anyone who is willing to offer it to me. No, you can't. Immigration advice in the UK is heavily regulated. This means that anyone who's not regulated to give immigration advice will be given immigration advice unlawfully and committing a criminal offence. And it's likely that you're engaging with someone who's not trustworthy and who doesn't have your best interests at heart when they're offering to help you for a fee. If you need legal advice, make sure that person is regulated. This means if they're a charity, check the Office of Immigration Services Commissioner website to see if they're present on that website. If they're a law firm in England and Wales, check the Law Society of England and Wales to see if the law firm is on that website. If they're a solicitor in Northern Ireland or Scotland, check their respective websites. So this is the last myth. Thank you for sticking with me. I hope this has answered most of your questions. If not, I'm here to help you with the rest of them. Thank you.
Thanks so much, Chris. Wow, what a comprehensive presentation. And hopefully that has, like you said, answered some of the questions that people and concerns that people might be having. One thing that's really, really, really clear coming through all those slides is there isn't any reason why you shouldn't be applying for settled status. You're much worse off, you're in a worse off position if you don't apply for settled status than if you do. So it's much better to do that. So we do have some questions. We're going to try and get through. I've got 4 here, and I think I've got 3 from various Facebook pages. So we'll try and get through these. So I'll read out the questions, and then either Chris or Pavel, if whoever feels most suited to answer it, please jump in. So the first question is, can a non-EU same-sex partner join me in the UK? I have pre-settled status. We are not married, but we have a civil partnership from another EU country.
So I'll take this question. So if you do have a civil partnership, then you can enter as civil partners, and you can apply as a joining family member, which means you can apply for an EU settlement scheme family permit. Once that's granted to you, then you can travel to the UK. Once you're inside the UK, apply for pre-settled or settled status within 3 months of arrival.
Great. Thanks very much for that one. So next question. If you are not granted settled or pre-settled status, what will happen when you go to access NHS treatment after June 30th?
I'll chip in for this one as well. So if you're not granted pre-settled or settled status before the end of this month, then have a look at the reasons why you were refused either status and try and reapply before the end of this month. You can still reapply as many times as you can fit in between now and the 30th of June. If you're refused after the end of this month, then you need to make sure you appeal that decision in time before the deadline to ensure that all of your rights and entitlements are uninterrupted. If you don't appeal and the deadline passes to appeal, then your rights and entitlements, including access to health treatment, will stop.
Right. So it's important to say at this point that if you've been refused and you're wondering why and you think you should have been refused, you can get in touch with Settled, advice@settled.org.uk, and they also have a multilingual helpline as well in many different languages to help you with that appeal or that second application. Next question. I provide services and find some EU nationals reluctant to apply because they fear having that application turned down. How can I convince them to apply?
This is one of the toughest questions we've all faced, because we're facing people who are reluctant to apply based on long residence or on principle because they didn't have a choice in the referendum, and many other reasons. And it's really hard to convince a person to apply. The best way you can do that is to explain to them what rights and entitlements are they currently enjoying in the UK. Are they in a job? Are they accessing health treatment? Are they receiving benefits? If they understand what they are enjoying now in the UK, then you'll be able to explain to them, well, if you don't apply before the deadline, everything that you've explained to me that you enjoy will stop on the 1st of July. And the hostile immigration environment kicks in. This basically means the full weight of the law is going to make your life immensely difficult to live in the UK. And also you may face immigration enforcement later on. So really, you need to ensure that you protect your status before the end of this month, despite your reluctance and despite this being an unfair position to be put in for votes that you had no ability to participate in. But the reality is we need to protect ourselves and we need to apply before the deadline.
Great, thanks very much, Chris. Next question. I have secured pre-settled status, but my job and family situation requires I enter and leave the UK regularly. And I know this came up a little bit in the midst. If I'm out of the country for more than 180 days in 12 months, what will happen?
Well, if you are outside of the UK for more than 180 days, but less than 12 months, and it's not coronavirus related, you are permitted one long absence, but it must be for an important reason. Unfortunately, working intermittently outside of the UK is not really considered an important reason for the Home Office, which means there are certain individuals, because by nature of their work, means that they're going to break their continuous residence in the UK because their work requires them to be outside for periods continuously over the 5-year eligibility for settled status. This does mean you're in a tricky situation. So really the best option available to you, if that's available to you, is to speak to your employer to explain to them and make them understand what those absences mean for your long-term prospects of living permanently in the UK, and see if your employer can make reasonable adjustments to ensure that you spend the most of your time inside the UK and not outside the UK. If your employer puts you in a position where you need to break your continuous residence and you make that choice to break your continuous residence, it means that you should speak to a lawyer before you try your settled status application. And if it's likely your settled status application is going to be refused, then you and your lawyer will need to figure out if there are other visa options available to you to continue allowing you to stay in the UK beyond your pre-settled status. But it's not an easy scenario. Unfortunately, you will need the help from your lawyer through this, for your employer through this, sorry.
Great, thank you very much. We have four more questions, which we should get time to get through. We'll just go slightly past 2 o'clock. These ones are slightly longer, so do bear with me. This question is from Shivko on the Settle Facebook page. I have quite a specific question. It's regarding an LGBTQ plus couple. One of the partners lives in the UK and has settled status. Another partner is in Bulgaria. The only way for that case is joining family member, but they have never lived together there, as the situation in Bulgaria is, which is a very homophobic country, especially in the smaller cities. Is there any possibility that they can prove the relationship?
Shall I jump in with this one as well? Now, the short answer is you're probably not going to be able to use the joining family member routes. This is because to be able to be a joining family member as an unmarried partner, then you'll need to have been living together for at least 2 years, or you have other evidence that you're in a serious and committed relationship. Now, it's unlikely that if you've had no period of cohabitation or very short periods of cohabitation, that anything less than the presence of a childcare, something of that type of level of evidence will prove that you're in a serious and committed relationship with each other. If all you've got is WhatsApp or Skype messages with each other, or even Zoom exchanges, that's probably not going to be enough to prove that you're in a serious and committed relationship, despite the issues that you face in Bulgaria. I think what your most likely solution is to consider the civil partner route or the marriage routes. But then, because that civil partnership or that marriage has occurred in 2021, you still won't be eligible under the EU settlement scheme. So you'll have to consider other family visas within the immigration system. But really, to use those other visas within the immigration system, you need to enter into a civil partnership, be married, or enter the UK to enter into a civil partnership or to become married. Without cohabitation, those are really your only options.
Great, thank you very much. So yeah, just a reminder that with these specific scenarios, if you feel like you need further advice, you can contact advice@settle.org.uk or phone them, or all the phone numbers are on the website. This is a question on Zoom from Nevin. What are there's slightly two parts to it, so bear with me. What are some of the options for transgender EU citizens with dual nationality? So the dual nationality being one EU country and one non-EU country, to get advice on updating their settled status when they change their name on their EU identity document. The guidance from the Home Office is quite vague and not very reassuring, and they've followed up with saying, in the interim guidance for transgender applicants who already hold settled status, the Home Office said they can only register a change of name if the applicant has changed their name and gender in all foreign documents. So if I change my name in my EU passport but not my Brazilian one, would I still be able to update my EU passport with EU settled status to guarantee that I can prove my status? Otherwise, the passport that I hold will be with a new name and gender marker, and the passport registered with them now will be invalid.
Now, I have to say, I'm not sure if the Home Office is correct on that. If you update your EU passport with your new details, and then you apply to have your new details reflected in your digital status, that should really be enough. I don't know of any Home Office policy that requires you to have every single passport updated and every single passport shared with the Home Office in order to do so. So I'm not sure if they're correct about this. I will check and I can pass on the details to Settle if I think if I'm incorrect by that. But I think if you update your EU passport, then update your status, digital status, that really should be enough. Bearing in mind that you need to be conscious about which document you use to travel into and outside of the UK then at that point.
Yeah, I think what it is that the guidance is vague, so that clarification is really helpful. Two more questions. Question on Settle Facebook from Tiffany. Due to COVID, I had to leave the UK to look after my mum in South Africa in March 2019. I have pre-settled status. Can I come back to the UK in March 2022?
I'm really sorry, you'll have to repeat that. My connection just dropped for a
That's
second.
absolutely fine. So, question from Tiffany on Facebook. Due to COVID, I had to leave the UK to look after my mum in South Africa in March 2019. I have pre-settled status. Can I come back to the UK in March 2022?
Okay, so the Home Office's new and updated guidance on absences does tell us that a person can be absent for more than 12 months if it's coronavirus related, and you can prove that it's coronavirus related, and you return back to the UK as soon as reasonably possible afterwards. Now, in their guidance, they do say that coronavirus related can be caring for family members who are vulnerable to the coronavirus abroad. However, I'm sure you will be testing the limits of this guidance because you've been absent for over 2 years. And so it is a significant period of time to be outside of the UK. And bearing in mind that some of that period was predating coronavirus. So it's not a straightforward scenario you're in, particularly as you're still outside of the UK now. So I would, because of the complexities of your scenario, I would reach out to Settled if you can, so they can go through your chronology and best advise you before you make any large commitments about returning to the UK, because you will need to return to the UK to reduce the length of absence outside of the UK.
Great, thanks very much, Chris. And one final question before we wrap up today. This is a question on Zoom from Shireen. Hi there. If someone is unable to apply because they are in bad health, can you apply on behalf of them? I assume they mean Settled when they say that.
Yes, I as a trustee of Settled, I feel I can say yes. Settled can help with this application. So long as we're sure, Settled sure that the person we're helping make that application understands the application is being made, they have capacity to understand what's being done on their behalf, and they can authorize that work. It becomes more complex if someone is in such serious health that they don't have mental capacity, or they're in a coma, for example, at which point there's going to need to be some legal coverage, such as a court order or protection order in place to prove that a third party can act on that person's behalf. But otherwise, if that person you're talking about is in poor health, and I hope they improve at some point soon, if they're in poor health but they still can communicate, then Settled can help with that application.
Great. Thank you very much, Chris. Well, what a wealth of knowledge you have on this, and it's been hopefully it's been helpful and reassuring to those people that have tuned in, and has answered some of the questions. Just to remind everyone that today's session has been recorded and will be available online afterwards, so you can access it on the Settled and the EU Delegation Facebook pages, and also on Settled's YouTube page. Please help us share and spread the word to our European friends, neighbours, colleagues, family members, especially to LGBTQ plus people and those living with HIV who might be worried about applying in relation to their sexuality, gender identity or HIV status. Just to remind as well that any question that's not answered, or if you want any further clarification on the question that you have asked, you can email advice@settled.org.uk with that, and that's the same address if you've got you want to ask for support with your applications from Settled as well. All that's left to say is thanks to Settled for hosting this event, and for the support from the EU delegation, and a massive thank you to Pavel, who I think's connection just lasted for his presentation, which was great, and for Chris for their expertise today. So thanks very much for joining us. Take care of yourselves and stay safe, and goodbye.